Hey everyone, welcome. I'm Doug Bennett, Director of the New York Tech Alliance, and joining us today is Rachel Beardsley, Partner, and Chris Gregorio, Senior Associate at Fragomen, a firm of more than 6,000 immigration-focused professionals and staff spanning more than 60 offices worldwide. Before we get started, I have a few items to share. Please know that we record our events to share with anyone unable to attend. Recordings are posted on NYTA's YouTube channel. You can subscribe to our channel and view this and past recordings by going to youtube.com/NYTechAlliance. For anyone joining us for the first time, the New York Tech Alliance is a nonprofit serving the New York tech community. And at the core of our mission, we drive access, equity, and inclusion to make the New York tech ecosystem the most diverse and dynamic in the world. To learn more about us and how to get involved, visit our website at nitech.org. Thanks to our annual sponsors who help make events like this one possible. Each has a presence on our website. You can learn more about them and how they support our community by going to nitech.org/sponsors. And if you're not aware, the New York Tech Alliance is part of Civic Hall Union Square, and we're both a part of the FedCap Group, which is a large nonprofit with history going back to 1935, when it was established to help disabled vets get jobs. Today, FedCap is comprised of 23 organizations that operate throughout the US, Canada, and the UK, with a focus on 4 key items: workforce development, economic well-being, education, and health and wellness. The Alliance operates out of Civic Hall's new 85,000 square foot digital training center located at 14th Street in Irving, right by Union Square. There's 3 key activities at Civic Hall: digital skills training and certification, meetings and events in the Craig Newmark Auditorium and Conference Center, as well as co-working membership for founders, entrepreneurs, and others in the tech ecosystem. To learn more about each, I encourage you to visit their websites, which are noted on the screen. We have a couple of upcoming events. I'm thrilled to invite all of you to a special screening of Origin in partnership with the Harlem Cultural Festival Foundation. It's this Friday, April 26th. Doors open at 5:30 p.m. So Origin, a provocative, powerful new movie from Ava DuVernay, tells the story of Isabel Wilkerson, the Chicago bureau chief of the New York Times, and first Black woman to win the Pulitzer Prize for journalism. Following the screening, a discussion featuring Oscar nominee Anjanou Ellis-Taylor is going to be held. You can scan the QR code in the graphic on the screen or go to the link noted on the slide and reserve your complimentary ticket. We hope to see you there. Our next New York Tech meetup is scheduled for Monday, May 13. We'll be hosting it at Civic Hall, and the demo theme will be disability tech. We're partnering with 2 fantastic organizations, the Perkins School of the Blind and their How Innovation Center, as well as Give Beauty Wings. We'll be announcing demo companies soon, but registration is now open on the Tech Alliance website. You can go to it by typing in nitech.org/our_events. And last, we love and welcome support to help us produce and deliver our programming. 3 ways you can help include attend as many events as you can, both in person and online, become an individual or corporate member or annual sponsor, or simply make a small donation. You can do so by going to nitech.org/support_NYTA. Okay, with that, I'd like to introduce and welcome Rachel Beardsley, Partner, and Chris Gregorio, Senior Associate at Fragomen. Welcome to both of you, and thanks for being with us today. Rachel, I'll turn it over to you.
Great. Thanks so much, Doug, and thanks everyone for joining us. We're just delighted to be here with you today. We wanted to focus on immigration strategies. So, certainly we hear from our corporate clients that immigration is a key talent acquisition and talent retention tool. And so we wanted to talk through some of those strategies today. to give you some visibility on what may be available to your business. With the visa process, there are applications for temporary work permits called non-immigrant work permits, and then there's also the green card process. So we'll cover both of those again, just to give you full visibility on what may be available to you. And we're glad to take questions at the conclusion of the presentation. So starting with just an overview of immigration, we've seen that immigration is top of mind in a lot of different contexts. The Wall Street Journal actually released a poll recently that for voters in the upcoming presidential election, immigration is actually the top issue that voters are considering. And so that is superseding the economy, which of course is normally the most important issue to voters. From an employment perspective, we're seeing employers rely more heavily on immigration, and particularly in the areas of science, technology, engineering, or mathematics, or STEM, where the STEM industry and roles in STEM are just growing exponentially, and there's a lack of talent in that area, and not just in the United States, in other countries as well. Countries are really vying for and competing for STEM talent. Coupled with that, of course, we are in a post-pandemic world, and with the pandemic, we saw a shift to hybrid work and remote work as well. And so that has, of course, changed the dynamics in terms of where workers are located, where they want to work, and that has an impact on employers as well. We wanted to highlight some of the skills shortages. We see that 55% of employers are willing to hire outside of the United States or outside of their country for talent. This was reported in a survey last year. And in terms of the technical skills that employers feel that they're lacking, IT and data tops the list, followed by engineering, sales and marketing, and followed by operations and logistics. So again, we see this highlighted that employers need talent. And again, in STEM fields, we're seeing that talent need and that desire for talent be particularly acute. We wanted to cover some of the government agencies involved. Again, we appreciate that immigration is in the news quite frequently, so just wanted to give you an overview of the players. The Department of Homeland Security oversees the U.S. Immigration Services, and so this is the agency that adjudicates applications for immigration benefits like work permit applications, green card applications, citizenship applications. The Department of Homeland Security also oversees ICE, which is Immigrations and Customs Enforcement, which is, of course, is the enforcement agency, and then Customs and Border Protection, which is the arm of the agency that secures the U.S.'s borders. The Department of Labor oversees aspects related to certain visa processes. So, for example, for some of the temporary work permits like the H-1B and the E-3 visas, a labor condition application is required that needs to be filed with the Department of Labor before the visa petition can be filed. Likewise, on the green card process for the labor certification or PERM process, there are steps that need to be filed with the Department of Labor. Finally, there's the Department of State. So the Department of State oversees the consulates worldwide. The consulates are tasked with overseeing and administering the visa stamp process. So the visa stamp, that's that sticker that goes in a person's passport, and that's actually a vetting process. So before a consular post will issue a visa stamp, the visa applicant goes through a very rigorous process where the agency vets them. So they're looking at, has the person reported having any communicable diseases? They do an FBI criminal background check. There's a very lengthy application that the person has to complete to show and confirm if they have any ties to terrorist organizations. They have to, in some instances, provide social media account information. So it is a robust vetting process that happens before the State Department will issue that visa stamp travel document. Excellent. So turning to some of the most common temporary visas, the B visa is a visitor visa, and also so this can be for tourism or for business travel. So a person does need to go to a consulate to apply for a B visa, and the permissible activities include, again, tourism, or if a person is coming in for business meetings or to attend a conference or seminar, all of those are permissible activities under the B visa. Similarly, the visa waiver program is available to individuals from countries that the US government has determined to be low risk. And so this includes many European countries, Australia, Japan, to name a few. So the advantage for individuals from visa waiver program countries is that they don't have to go to a consulate to get a visa. Rather, they can register through an electronic system for travel authorization, or ESTA, to have that travel authorization online, and then they can enter the US for business travel or for tourism. The F1 visa is for students, so this would be for students attending a US university. What's critical from an employer standpoint is that F1 students can apply for work authorization in limited circumstances. So that includes the curricular practical training, or CPT. And so that would be for a summer internship or even an internship during the semester. After graduation, an F1 student has what's called optional practical training, or OPT. Initially, OPT is valid for 1 year and then can be extended for an additional 2 years if the person has a degree in science, technology, engineering, or mathematics. And so with a STEM degree, a person has up to 3 years of F1 student work authorization, which is a great platform in terms of the next step of work authorization beyond the F1 OPT status. Finally, there's the J1 visa. The J1 visa covers a lot of different types of activities. So it can be for an au pair, it can be for an intern or trainee where the person has attended university outside of the United States. And those latter two categories are the most common ones that we see from a business perspective. So again, this would be for someone who attended a foreign university and is coming to the US for training. The H-1B visa is one of the most common work visa categories. And the reason being is that it's fairly universal. So there are no citizenship requirements. And in terms of the eligibility criteria, the position must require at least a bachelor's degree, and the applicant must have a degree that's directly related to the position. So it's great in terms of how broad it is. The challenge, though, with the H-1B visa is that there's very high demand, and the government has put in place a cap or quota on the number of H-1B visa numbers available. So specifically, there are 65,000 visas available under the regular bachelor's cap, and an allocation of an additional 20,000 visas for individuals with US master's degrees. Every year, the Immigration Service runs a cap lottery to see what cases will be selected for processing. So the registration process occurred in March, and the lottery process occurred at the end of March. We're actually now in the 3-month filing period. But again, the challenge with the H-1B is just the high demand, where this year, for example, it was about a 25% selection rate, and that is consistent with the prior years as well. The H-1B visa numbers and the number of applications really follows the economy. So when it's a strong economy and employers are hiring, then it means typically that there are high numbers of H-1B cap registrations as well. Once a person is granted H-1B visa status, then they're no longer subject for that cap for future extensions or transfer petitions. So a person may change employers, or they can extend their status with an existing employer, and that's valid for up to 6 years. So while the H-1B is fantastic, we do, of course, look to other options just because there's no guarantee of selection in the H-1B cap lottery. Another great option is the L1 intra-company transfer visa. So this is for international companies. So it allows a global company to transfer an employee from an office outside of the United States to the United States, provided the person is in a managerial or specialized knowledge capacity. The government does require that the person have at least 1 year of experience with the organization abroad prior to the transfer. For managerial positions, they can extend their status for up to 7 years. And for specialized knowledge roles, they can extend their status for up to 5 years. The E2 visa is for treaty traders and treaty investors. So this is based on treaties between the United States and over 50 countries. It's quite a broad list. And for the E visa, the company must be majority owned by nationals of the treaty country, and the visa applicant must hold that same citizenship. And so let's say that it's a French-owned company, then the applicant likewise must be a French national as well. The E visa is very versatile because it can be used for startups. So I think it's a great option for entrepreneurs where the business is just launching. And, let's say that it's your own business and you're the sole owner, then as long as you're from one of those treaty countries, then you meet the citizenship requirement, and likewise your company meets that citizenship requirement as well. On the other end of the spectrum, large global companies use the E visa as well, again, as long as they can show that they are majority owned by nationals of that country. So shifting back to filing an E visa for a startup, the government does require that an entity be formed. So whether that's an LLC or a corporation, a C Corp, the business must have substantial funding to be able to get the operations off the ground. There needs to be a business plan showing, what clients are targeted, plans for hiring additional employees, any contracts with vendors, really to show that a lot of thought has been placed into, getting the business off the ground, and what the plans are to have the business be profitable. The TN visa is for Canadian and Mexican nationals in certain occupations. So the occupational list is quite broad. It does include a lot of science-based positions like engineers, computer systems analysts, and it has a wide variety of other positions like lawyers and accountants. And so it is one of those visa categories where the position needs to directly match one of the occupations on the TN list. So it's not enough that a person is a Canadian or Mexican national, but beyond that, they need to be employed in one of those occupations. But it is one of the options that is great as long as the person meets the citizenship and position requirements. The H-1B1 visa also has a citizenship requirement. So this is specific to Singaporean and Chilean nationals. Similar to the H-1B visa category, it is for professional positions that require at least a bachelor's degree. This is just a special carve out for Singaporean and Chilean nationals. So if a person holds citizenship from one of those countries, then they're exempt from the normal H-1B cap. Finally, in terms of the visas based on citizenship, there's the E3 visa for Australian nationals. Here again, this is for positions that require at least a bachelor's degree, and the person must have a bachelor's degree in a related field. The E3 visa is readily available to Australian nationals, so there again, it's a great alternative to the H-1B. Finally, for the O-1 visa, this is for persons of extraordinary ability. So this includes someone who is in the top 1 to 2% of their field of endeavor, and they need to show evidence in at least 3 of the 8 O-1 categories. Those categories include national or international awards, membership in associations that require high achievement of their members, media about the person's work, judging the work of others or speaking on a panel, original contributions of major significance to the field of endeavor, articles written by the person, holding critical positions at distinguished organizations, and finally, commanding a high salary compared to others in the field. So again, you only need to show at least 3 of those categories, but we try to present as robust of an application as possible, just to really put the strongest case forward. The Biden administration has really prioritized STEM talent, and that's a key theme that we'll cover through a few different sections here. But one of the ways they've done that is actually through the O-1 visa category, and the administration provided guidance that adjudicating officers should really strongly consider O-1 applications for STEM talent when the individual has a graduate degree, so a master's degree or a PhD in a STEM field. Again, at the end of the day, the person still needs to show at least evidence in at least 3 of those categories. But, I think it is helpful and really a step up that the administration has flagged for adjudicating officers, just the importance of STEM roles to the administration. So we did want to just cover a few fact patterns just to bring this to life. So situation 1 is that your colleague from a foreign office is coming to the US to cover for another US colleague's parental leave. The colleague from abroad plans to enter as a business visitor for 6 months and will be paid in the US. So the question is this a violation of permissible business visitor activities? Anyone want to take a guess? You can take yourself off mute, or you can put it in the chat. Okay, well, no brave volunteers there. So the answer is it's not permissible. And that's a question we see come up frequently from clients, where the client may only be focused on the amount of time and not on the activities. And so for a parental leave, where someone is coming to cover and to work, it's not possible and it's not permissible to work on a business visa. And so even if the amount of time would be covered by a visitor visa, you still need to look at the activities that the person will perform. In our second situation, let's say that you are interviewing 2 university student candidates. One has shared that he completed full-time curricular practical training for 12 months. And the second candidate mentioned that she's STEM eligible, but her degree is in finance, according to her resume. So a few red flags here. One of the exceptions with CPT is that if the person uses 1 year of full-time CPT employment, then they're actually not eligible for OPT after graduation. The policy reason behind that is that the government doesn't want the person to be able to double dip. And they feel that if a person has received and been approved for 1 year of full-time employment under CPT, then it would really be duplicative to grant that person a year of employment under OPT. For the second part of the fact pattern, typically finance would not be a STEM degree, and the STEM degrees are actually defined by the government, and so there's a list. So a person's degree is on the list or it's not. And I will say that the Biden administration has expanded the degrees that qualify as STEM degrees for the purpose of allowing additional people to be eligible for that 2-year STEM extension. But, at the end of the day, that degree still does need to be on the STEM list. So in that instance, you would want to just encourage the candidate to go back to her university and just confirm, have the university confirm if she's eligible for that STEM extension. And so finally, let's say that you're onboarding a candidate and you learn that the candidate requires immigration sponsorship. This is a less than ideal scenario for our clients. And what we hear from our corporate clients is that they don't like surprises. And that's totally understandable, that they would not want to have a surprise. It is possible for employers to ask if a person will require visa sponsorship now or in the future. And, if the person answers affirmatively, you can ask follow-up questions about, what types of visas they've held. Are they in the green card process? Are they currently employed, or are they between jobs? So, in terms of immigration program management, the way we partner with our corporate clients is really trying to help them identify candidates early in the process who will require visa sponsorship. And then we help them assess what are the visa options, the timing, and the cost, as well as any risks.
Great. So for the next few slides, we wanted to cover a high level focus on just the impact, and as Rachel had mentioned, the prioritization by the Biden administration on STEM-related degrees. Now, there is the STEM OPT that Rachel had alluded to. There are a variety of fields that do fall within that, as mentioned as well. It continues to change and evolve. So that is one thing that we do see with the Biden administration, that there is an acknowledgement how STEM-related fields continue to grow. And as a result of that, many individuals benefit from this continued expansion of STEM fields. What once maybe was not considered a STEM degree when someone enrolled in their university could be a STEM degree when they graduate. And it's important to just have any conversations. If you specifically are impacted, have those conversations with your university, with your designated school official. If you have any employees that fall within that fact pattern, if you will, just to encourage them to have those conversations with their university. STEM benefits are quite grand, and we'll cover this at greater length. As Rachel had mentioned, there's the additional 2 years of work authorization through that STEM OPT. We have also seen the continued usage and expansion of various immigration benefits given to those individuals who have that background in STEM-related areas of focus. AI is a big one, as the right-hand version of the slide mentions. And you'll see there that prioritization through the executive order took place in just October of last year. So we're really at the forefront of many new avenues of relief that are open to individuals, that are open to employers. It's an exciting time for individuals who have that STEM-related field. The U.S. government, the administration has acknowledged that there is a shortage of U.S. talent in these fields, and as a result of it, don't be deterred if you're not selected in a lottery, or maybe at the outset it doesn't seem like a visa is immediately available to you. There could be other avenues there which you can explore. So in terms of the immediate avenues, we've discussed some, as Rachel had included those slides. Now, there's the other part of it, which is the more permanent part of U.S. immigration, and that's the green card, or lawful permanent residence. So there are a variety of avenues by which an individual can file for a green card. So a common one is family-based. So if someone is married to a U.S. citizen, for example, or someone's spouse holds a green card themselves. There's also a diversity visa lottery. It is quite a difficult process to be selected. The selection rates are often very, very low, much lower than a selection rate for the H-1B cap lottery, for example. It does open in the fall of every year. So if you are eligible, there are certain individuals from certain countries who are eligible. There are some certain countries that are not. Essentially, it's for those individuals from countries that are not commonly found within the normal course of other green card recipients. So not commonly found, through example, from employment-based green cards. And that segues into the other one, employment-based green cards, which is one of the most common areas of securing a green card. It's through employer sponsorship. Though there are some limited instances where an employee, an individual, can self-sponsor. I would say more common than not is employer sponsorship, but there are some areas where someone can self-sponsor, and we'll cover this in more in depth, but one of which is what's called the National Interest Waiver, or the NIW approach. And then there's the investment-based option. That's through the EB-5 Regional Center Program, which you may be familiar with. It's through an investment in the United States. There's various thresholds depending on where you're investing, but essentially the heart of the program is based on an individual investing to promote the growth and sustainment of U.S. jobs. And so there are some certain avenues there where you don't need to go through an employment-based option. And that's really what the purpose of this slide is looking to portray. So as mentioned, family is a key area. So for individuals who have immediate relatives is the term of art. And there are many terms of art within the field, but that is the term of art there. So for those individuals who have spouses that are U.S. citizens, for example, that's a common area of receiving family-based sponsorship. And it's not subject to quotas or backlogs. So many other green card paths are subject to quite extensive backlogs, whereas for someone who's married to a U.S. citizen, for example, there's no backlog. You can immediately file for the green card once you have that marriage certificate in hand. And then there's other options as well, though these do carry, as that bottom bullet point notes, much more extensive waiting periods, depending on what category you are being sponsored on. So brothers and sisters of U.S. citizens, or unmarried sons and daughters of U.S. citizens, they all of which carry a backlog. It just depends on which category. And on that, without really delving into the specific backlogs, each month, the State Department releases what's called a visa bulletin. It details who in queue is able to have a green card filed on their behalf. It's released publicly. We track it as well. It's usually released in the middle of each month, and it details who is able to have a green card filed, not only on the employment-based side of it, but also on the family-based side of it as well. As we dive a bit further into the employment-based options, one of which is reserved for what's called EB-1 or priority workers. And the EB-1 classification is generally one of the higher bars to securing a green card. And it's broken down into a few different subsets. So the first of which is for individuals who have extraordinary ability, and that can be in arts, science, athletics. The field can be quite vast. It can be sponsored by an employer or self-sponsored. It is truly for those folks who are in the top echelon. There are 8 criteria, and usually we say, well, the minimum is 3, but usually we say the more the better. So if an individual is able to satisfy at least 3 of those criteria, and they fall into the realm of citations, publications, judge of the work of others, whether or not someone has held a critical role for various organizations. So there are a variety of criteria there, and the minimum is 3 of the 8. The other of which are for outstanding professors and researchers. And now for outstanding professors and researchers, it really digs much more into the publications of that individual, the citations of that individual, and where that individual is working. So really looking at the tangible impact of that work and how an individual's field, through publications and through citations, has acknowledged the importance of that individual's accomplishments within that respective field. The last one is called the multinational manager category, and that's reserved for someone who has worked with an employer outside of the United States in a managerial or executive capacity, and then who is working for that same employer, so their US office, for example, in a managerial or executive capacity. So it does require 1 year of employment abroad at a at a foreign office, and then again, employment in a US office in a managerial or executive capacity. So the EB2, or the national interest waiver, it is becoming, and I jumped to the bottom of the slide because it's really becoming one of those avenues of relief that we see many more employers and individuals pursue. The one thing I would say is that when you hear that term national interest waiver, you may have some sticker shock in terms of, there's no way I can apply for this. The national interest waiver sounds like it's way over my head in terms of my accomplishments. And I would say that don't let that term deter you from potentially exploring its viability for you. While it doesn't provide an immediate work authorization, it could provide a much more expedited approach to a green card. So it is an area where we see individuals primarily, as mentioned, with STEM-related degrees pursuing. The term of art is a field of endeavor. So ensuring that that individual has essentially continued to and will push their proposed field of endeavor forward. And that is not a rigidly defined term. So essentially by that, it is, well, what are you working on, or what have you done? What is an accomplishment that you've worked on? And really looking at it in the current world, is it something that we can be seen as advancing that proposed endeavor forward? So for example, if someone is involved in developing software related to e-banking solutions, the world, United States included within that, is so reliant upon electronic banking and electronic payment solutions that there could be an argument there. So it's really, again, really important that when you look under the hood of this category, to dive into your specific background, your role, your impact, to determine the viability and the feasibility of such a filing. With this, the EB3 category, this is commonly sought after through an employer-sponsored process, which is also referred to as the PERM process. So the employment-based green card, or the PERM process, does lead to sponsorship in the EB3 category. And again, that's one of the categories that's released by the State Department through their visa bulletin on a monthly basis. Now, the PERM process, or the permanent residency process, is covered in this slide. This provides a bit of a high-level overview as to how that process unfolds and the various timings surrounding each stage. There are a variety of steps that fall within each stage, predominantly stage one. Stage one requires, again, employer sponsorship to initiate the process. There's usually a drafting of a job description and minimum requirements by that employer and legal counsel to assist with the various finalization of that job description. Then a preliminary submission is filed with the Department of Labor called the prevailing wage request. Essentially what that is that the DOL wants to review the credentials of that position, and they want to determine what should be the wage for that position in that specific area. So what is the software engineer wage for this position based on the minimum requirements in New York City, for example? And then once that's been received, employers commonly then go through really the heart of the PERM process is what's called a recruitment step, or a labor market test. And essentially, the way that this process has been set up is that it's about a protection of the US workforce. So in order for an employer to sponsor someone through the PERM process, this labor market test must take place. And there must be a good faith determination that no minimally qualified US workers have applied to this specific position. It usually takes a couple months time. The PERM process is a bit archaic in the sense of the forms of advertisement that must be used. So there are 6 forms of advertisement. So for example, 2 Sunday newspapers. Not sure how commonly individuals are utilizing Sunday newspapers to seek jobs, but it is a requirement. And there are 6 forms of advertisement which must be completed. And then within that time, an individual and that employer will need to, again, come to the determination that no qualified workers have been identified. Once that's done, the perm application can be filed and really push the ball forward to the stage 2 and stage 3, which is that I-140 immigrant petition, which is what we had discussing at the outset, which is either the EB2 or EB3. And then from there, the potential green card filing, or the I-485. So there are a variety of steps. This process can take years commonly. For individuals born in India or mainland China, it can take many years to get to that final green card approval. So it does vary based on the time and based on the country of birth. And that's the other key factor I wanted to talk about, is that the backlogs associated with that visa bulletin and the particular category, either the EB1, EB2, or EB3 that we've been discussing, based on your country of birth, so not citizenship. That's ultimately the gating item or items which then allow an individual to be able to file for their green card application itself. So then just moving ahead and back to the discussion of the EB5. So there are a variety of thresholds, as mentioned, depending on where an individual is looking to invest. So it does vary between 800,000 to just over $1 million. And with the investment, it's important that that project will lead to sustained growth of U.S. positions, the U.S. workforce. There are commonly what are referred to as regional centers, which do assist with these types of EB5 classifications. Essentially, we usually and only work with reputable regional centers, which are backing projects, which there's a stronger expectation that the project will be seen through fruition and that the project will lead to those development and sustainment of U.S. jobs, because the money is at risk. So that is something that we do work closely with these various regional centers, which assist in these and handle these various projects, these development projects in either rural areas or high areas of unemployment. So in terms of issue spotting, again, just to potentially bring this a bit to life, is, what I would say is, with all of these scenarios, to some of the various issues that Rachel had mentioned and some of the various issues that we're covering here, is that there's a lot of bad information online. So it's always really important that whenever you're going through the U.S. immigration process, I wouldn't do a lot of Googling. There's just a lot of misinformation out there. And that's where it's important always to review the primary documents that you're looking at, or to check in with counsel as well. If your company has legal counsel, you'll want to just engage them and their counsel with these types of questions. Now, as it relates to some of these various scenarios, the first of which is that your firm is onboarding a new employee and their green card application has been pending for many months, specifically 8 months. In this situation, it may be possible for your company to actually pick that application up, which could allow for a significant result in cost savings. It could also result in a much smoother process of onboarding for that employee. Now, for situation 2, we're seeing this much more frequently. The pandemic has, really ripped the Band-Aid off on how many employers are operating, particularly with work from home or office closures. We're seeing that happen much more frequently across the board. And so if there is an office closure, or if an employee is working somewhere in, let's say, New York, and says, I want to work permanently up in Portland, Maine, for example, then that could impact their immigration process. That could impact their pending green card process. So really important to just have those conversations and assess before any action is done. Again, could lead to a potential impact in their work authorization or potential impact on your bottom line, just with the fees associated with restarting the process. And then layoffs, another key area that we've seen, more unfortunately over the course of the last few years. Layoffs can impact the green card process, specifically the perm process. It could delay or impede an employer's ability to file a perm application. So it's always important to keep in mind that when you're going through any of these processes, that you're really taking a holistic approach, not only just looking at the specific application for that individual, but the business model that you have, any future planning, looking ahead into the future to the extent you can to see, are layoffs coming? Do steps need to be taken on a more expedited basis? And it really allows for not only the smoothest process or the more seamless process for you as an employer, but also for your employee and their families as well. With that, I'll turn it back over to Rachel.
Great. Thank you, Chris. So we wanted to look at immigration trends and what to expect for the year ahead. I know for all of us, all eyes are on the upcoming presidential election, and immigration will certainly play a key role in the election. From an immigration perspective, if President Biden is reelected, we would expect a continuation of policies. And overall, we've seen policies that are favorable from an employment-based immigration perspective. And we've seen some improvements, such as the focus on STEM that we've discussed. There's a domestic visa renewal pilot that we'll discuss later in the presentation, and some other positive developments along those lines. At the end of the day, those developments and those improvements are incremental. And the reason why is that for many steps with immigration, Congress needs to get involved in and approve. And as you may be aware, it's been several years since there has been any comprehensive immigration reform that's been approved by Congress. One of the challenges there is that when Congress addresses immigration, they try to fix everything. And, at the end of the day, immigration is very vast, where, our day-to-day is dealing with executives and other professionals for, very skilled positions. And there's a need, and businesses have that need. And on another end of the spectrum is the crisis at the southern border, the U.S.-Mexico border. So that well, yes, it's all immigration. It's very diverse, and the solutions are quite different. So, from an administration perspective, certainly we're not expecting any other major immigration changes this year before the election. Of course, there was the border security bill that was proposed at the beginning of this year, and then that failed in Congress. So we're not expecting any major changes there. If former President Trump is reelected in November, then what we would expect from an immigration perspective is similar to what we saw in his first 4 years in office. So there again, there was a focus on immigration. It manifests as really a lack of predictability from an immigration program management stage, where you may recall that there was a travel ban put in place that impacted some individuals from Middle Eastern countries, and that was then challenged in court and overturned. There was an increase in salary levels that again was challenged in court and overturned. So again, from putting ourselves in the shoes of business people and business executives, that lack of predictability makes it hard from a business perspective. We also saw just more hurdles in the process. At the end of the day, we were still getting cases approved for our clients, but there were more requests for evidence, which is basically an audit by the government. There were instances where the request for evidence rate for a particular visa category doubled under the Trump administration as compared to what it was under prior administrations. There were more robust documentation requests. So in the green card process, the Immigration Service implemented a new form that required very extensive financial information from the green card applicant, such as credit reports, mortgage statements, bank account statements, investment statements. It turned into a filing of hundreds of pages of financial documents. And again, at the end of the day, the cases were still getting approved for our clients, but it made the process, those types of steps made the process more arduous. So more to come as we approach November. We did want to take a look at a few other developments. One of which I just mentioned is the domestic visa renewal pilot. So typically, a visa applicant needs to travel abroad to a U.S. consulate outside of the United States to apply for a visa stamp. And again, that visa stamp is a travel document. So if a person is in the U.S., she can actually renew and extend her status, her work authorization from within the States. But if she's choosing to travel, she does need a valid visa stamp to return. What had happened during the pandemic is many of the consulates were closed for several months because of the pandemic, and then even as they reopened, they had a skeletal staff, and this resulted in a very lengthy backlog, and demand for visa appointments was quite high. So the State Department launched a pilot program to enable individuals to apply for a visa stamp from within the U.S. And so it was a very limited pilot, only for H-1B applicants who had applied for H-1B visas at certain consular posts within a certain time period. And so the pool of eligible applicants at the end of the day was quite small. But we do expect for the State Department to expand this pilot program incrementally. And from an employer perspective, it's great, because if you have an employee who's traveling abroad, they may be gone for a week or two waiting for the visa stamp to be issued, and that's a business interruption. So it's better for the business if the person stays within the U.S. And it's also better for the employee because, of course, traveling abroad for a week or two incurs significant costs. And again, there's buy-in from the State Department because they don't want to have lengthy backlogs at their consular posts. They want to be responsive to needs. So hopefully we do see this pilot program expanded. Another recent policy change was employment authorization for spouses of certain visa holders. And so the spouse of an E or L visa holder is work authorized. Historically, that spouse would need to apply for an employment authorization card, which could take a few months or sometimes even several months. But now those spouses are work authorized pursuant to their status. And so once they enter the U.S. as an E or L dependent, they are automatically work authorized. So that's a great improvement for those families. For H-4 spouses, they are not automatically work authorized. They do need to apply for an employment authorization card, and the H-1B worker must be in the green card process. And so H-4 spouses are eligible for an automatic extension of their work authorization if they have a valid entry record, which is that I-94 card, and they have a timely filed extension. But more restrictions on H-4 spouses, but still some overall improvements for dependent spouses with work authorization. One piece of not so good news is the Immigration Service has increased their filing fees. And the reason they've shared is that, as we've heard in many different industries, costs have gone up, there's been inflation, and so many of the filing fees have increased as of April 1st. Similar to what we were discussing with STEM talent, the White House recently released an executive order related to AI talent. So this is, again, just a continuation of that theme related to STEM talent. But the executive order directs the State Department to streamline visa appointment processing timelines for individuals who seek to study or conduct research in AI. Again, we're seeing prioritization of individuals applying for work authorization as well, and we see some of those specific categories on the next slide, such as with the O1 visa. Again, that's for extraordinary ability. National interest waiver applications, which is the green card process that Chris talked about. And then also for the J1. So for individuals with a STEM degree, they're now eligible for up to 36 months of practical training. And that's an increase from 18 months, which was the prior benchmark there. One improvement during the Biden administration has been a return to a long-standing practice of the Immigration Service. And so the agency's long-standing practice throughout multiple administrations, the Bush administration, the Obama administration, just to name a few, was to give prior deference to their prior approvals. So what that means in practical terms is if a person, or if the Immigration Service approves someone for an H-1B visa, let's say, then when that company files an H-1B extension for that employee, the Immigration Service will give deference to their agency's own prior approval, as long as there are no material changes in the position. And it makes sense. If the agency already approves someone for a particular visa category, then when that person comes up for extension, again, as long as there were no substantial changes, it makes sense that the agency would stand by their original approval of that visa category. However, during the Trump administration, they actually phased out the deference policy. And that was one of the contributing factors of why there were so many requests for evidence during the Trump years, because the Immigration Service was issuing requests for evidence not only on initial filings, but on extensions as well, where they were re-examining their own colleagues' prior approval of a visa application. So this is an area that we could see a change where if former President Trump is elected again in November, this could be a policy that is resurrected again. And we wanted to share some general advice for you as employers, and when you're speaking with any sponsored employees. We do recommend that individuals on visas keep copies of everything. It comes up throughout their immigration journey, and so it is important for them to have paper documentation of their comprehensive immigration history in the United States. Also, certainly there's a lot of information available online through ChatGPT, Alexa, Siri, amongst others. And at the end of the day, immigration is really complex. So we do recommend speaking with immigration counsel because it's so fact specific and evolving, ever changing. And so it is important to get the right advice, whether you're an employer and you're looking to sponsor someone on an employee, or if you're on a visa yourself. This is important, and it's important to get it right. So with that, we're certainly happy to take questions in the large group format, and then we'll also have some breakout rooms after this as well. So if you want to share any questions, feel free to put it in the chat, or you can take yourself off mute.
Rachel, it's Doug here. So I don't know if you mentioned this earlier on, but I'm curious about the scope of the number of applications globally, and what's the size of the issue. You mentioned before that there are 65,000 visas that are issued annually and another 20K. So is that, and then you went through different categories, and there's different numbers associated with those categories, but I'm just curious, globally, how many people are applying to for visas at any given year?
It's a great question, Doug, and it's not a data point that the Immigration Service shares. So I guess we see snippets of it where for the H-1B visa category that you just mentioned, last year there were 780,000 applicants against the overall cap of 85,000. And last year and the prior years were somewhat of an anomaly where the Immigration Service actually launched a fraud investigation through the Department of Justice because they discovered that some individuals were trying to abuse the system and were submitting multiple applications where there were not multiple job offers. And so that 780,000 is somewhat inflated. From the visa applicant perspective at the consulates, the State Department doesn't share that number, but I guess we see the effects of that in terms of delays. And so, sometimes right now, overall, the consulates are pretty good in terms of appointment availability, but emerging from the pandemic, sometimes it could be a wait time of a few months, or it could even be, 8 or 9 months at consulates that were really backed up. Another data point we see in terms of numbers is with the employment-based green card process that Chris discussed. So Congress allocates 140,000 employment-based green card numbers per year, and that's broken down through the categories that Chris talked about, like the EB1 and EB2. So it's a good question. It's just not a data point that the government reports on holistically.
Got it. Yeah, you bring up another point that I was curious about is who drives all the policies? Is it driven mainly through Congress, or are there other agencies that drive it? Is it driven by politics mainly, or?
All of the above, really. So yes, Congress has the highest level of authority, and for any major impacts like increasing the number of H-1B visa numbers or increasing the number of employment-based green cards, that would take congressional action. And certainly there have been advocacy efforts over the years by Zoe Lofgren, for example, in California, and other senators and congressmen to really try to carve out employment-based immigration from the rest of immigration and say, listen, we need employment-based immigration reform to attract and retain talent. This is a business issue. So yes, it's under the broad umbrella of immigration, but at the end of the day, it's a business issue because businesses need top talent. And sometimes that top talent is from outside of the United States. That said, we do see incremental steps taken by presidential administration. So of course, we talked about some of those steps by the Biden administration, like the executive order relating to AI, the domestic visa renewal, DACA, the Deferred Action for Childhood Arrivals. That was a policy by the Obama administration. So for some of those more discrete policies that can be taken by a presidential administration, but for the broader steps, that does need congressional intervention.
Got it.
I do see a question in the chat as well.
Yes, and before you get to it, Rachel, I'm going to ask Liberty to turn on all the cameras in case somebody wants to ask the question in person. Can you do that, Liberty? Thank you so much. Okay, very good. Sorry, Rachel, go ahead.
Great, thank you. So the question in the chat is, how do immigration professionals and authorities verify the credentials of foreign talent? So that's a great question. And so certainly if the person has a US degree, we submit the copy of the diploma and the transcript. For foreign degrees or degrees outside of the United States, there are companies that will review the credentials, and those companies rely on a standardized system called EDGE, which is the Chris, keep me honest, the electronic database for global education.
I believe that's it. Yep.
Okay.
Yeah.
So yes, there's a process, and the Immigration Service does accept those degree evaluations that are provided by credentials agencies, and they are quite accustomed to seeing those types of credentials evaluations.
Hello, I was going to ask that question, and there's a continuation to that question. So basically, what we are doing is we're actually building a company around that, where, I mean, strictly for now, people from Africa and to an extent, um, a very large number of people from Africa come to the United States for education, and also they get direct jobs sometimes. So it's about migration of their academic history from Africa, and how we can help them to just give the people who need to verify their records a direct access to their records that they have from Africa already. So I wanted to send you a mail. I was actually waiting for your slide for the email to actually send you an email around that later on.
Sure, yes, feel free to send us an email. We're more than happy to help.
Okay, thank you.
Welcome.
Okay, I think,
Chris.
all right, go ahead.
Hi, this is Maxim here. Thank you for presentation, and I wanted to ask, like, how early in the age of startup or company, your company basically is ready to help and practically help with like employment of software engineers and data engineers. Thank you.
Chris, do you want to take that one?
Sure. So I guess my question in return is just how early, now if it's an employee who is outside of the United States, I mean, we're able to assist at the outset, depending on what potentially may be viable to that employee and to you as the employer. If it is someone who's in the United States, we usually get involved similarly, but really at the outset. So looking to assess, say if that person is already employed with you, we usually like to review the documents, like to see how much work authorization that person has. What steps should you as an employer take during that current individual's work authorization? So maybe they're on their F1 OPT, and maybe it's important for you as an employer to sponsor that individual in an H-1B cap lottery, for example. And then if they're not selected in the cap lottery, then maybe are there other contingency plans that can be pursued? Maybe they're an Australian national or Chilean national, or maybe they're available to this NIW approach, which could fast track the green card process before there's an expiration of their STEM OPT. So I would say the common thread through both is we're usually involved at the outset, and we try to get involved really as soon as possible. But I think in terms of the analysis, it would depend on whether that individual's in the States working for you, or is that individual outside of the United States, and what other options could be available to both you as the employer and specifically that employee.
And quick follow-up question, like in terms of like
Sure.
the other side, if employer, like what is the stage of maturity of employing startup or enterprise? Would you say that you are like you had both startups and enterprise clients, or is it differentiate?
Yep. Yeah, absolutely. And great question, Maxim. So yeah, so we have helped with many startups. There's a visa classification honestly reserved for those types of startups. It's called the E2 classification. So it is reliant upon an individual having a citizenship that does allow for essentially there are treaties involved with various countries. And the E2 classification does allow for individuals to start their companies in the United States. It requires an individual to go through a business plan development. So looking to see, so first and foremost, we want to confirm for the E2, does that individual have a citizenship that would allow for the E2? If so, then we look to develop a business plan or really look to that individual to present information to us, which we can help in the formulation of a business plan. The immigration services want to see that that business, that startup, when that person lands in the States, it's essentially a turnkey operation, you know, that they're able to get their visa and then really hit the ground running. So oftentimes that requires a lease, any type of electrical bills, if you have contractors that you're working with, payroll companies. So really showing that there's more to that business than just the financial backing, if you will, that there's this expectation of continued advancement of that business in the United States financially, but also from an employee perspective, that there will be continued growth of the employee population within the United States. And we've helped with those consultations and those types of startups quite frequently for a variety of companies, everything from financial services to liquor distribution companies, one that just came to mind that we were working on. So, you know, it's very fact specific, but there's not a specific bucket or umbrella that we look for. It's really based on the business and what that individual is able to put through for their business plan.
I see. So basically, even for those who are outside.
Yes, absolutely. And that's commonly, Max, some good follow-ups, and that's commonly the approach where someone's outside of the United States and they're looking to start their business within the United States. The E2 is a common visa classification that we have sought after for individuals who are looking to start their business in the U.S.
And if the business is already started in US, it's like it has US citizen and everybody else, do you have any differentiation for that?
So the E2 could still potentially be an option for the individual. There's also a potential for other types of classifications, depending on whether or not there's a connection to a foreign office, for example. So sometimes there's and this is called an L1 visa, which we had covered, which is where an individual has operations outside of the United States. They've been working there for at least 1 year, and then they have an office within the United States as well. It's called a new office visa. So that's also a potential option. Again, there could be once kind of digging into it, there could be other options and visa types that come to mind, but those are just a few based on, you know, some of your initial comments.
Much appreciated. Thank you.
Great.
You're welcome.
Well, we actually set up some breakout rooms that we can that you can all enter. If you if you want to stop here and move on to that, I'll conclude things here and just thank everyone for being with us today. And hopefully you learned a thing or two. I know I did, and why we need you guys to cut through all of this. If you'd like to go to the breakout rooms, if you go to the bottom of your screen, I believe it's under the More button, you would just click on breakout rooms, and there's 3 of them. There's one for Rachel, there's one for Chris, and there's one for myself. So we'll all deploy into each of those rooms, and if you'd like to talk to any one of us further, please do so. Okay. Rachel, Chris, thank you so much for everything. This is fantastic, and really appreciate you.